This is the Law Guide tutorial. Today, we'll be looking at misrepresentation as one of the vitiating factors under the law of contract. In our discussion, we'll be looking at the meaning of representation terms and misrepresentation. So we'll consider the circumstances under which a misstatement will not amount to a misrepresentation as to found an action. We'll consider silence and misrepresentation, what the rule is, as well as the exceptions. Then other requirements such as the representation must be addressed to the party misled, inducement. Then we'll consider also kinds of misrepresentation, and then what the remedies are available, and also consider the limitations to that remedy. Misrepresentation. Let me make this clear. I will be referring to misrepresentation as misrep in our discussion, so you don't get confused when you hear misrep. Misrepresentation is one of the vitiating factors under the law of contract. It is a vitiating factor because its presence may negate the apparent consent of one or both parties to a contract and thus render the apparent contract unenforceable in some respect. A contract may be well formed, containing all the necessary elements to make it valid, but still be unfair because of something in its formation. For example, what if a person was encouraged into a contract because someone lied before it was made? Or suppose that Kwesi agrees to sell a second-hand car to Philip for 25,000 Ghana cedis, and in the course of the pre-contractual negotiations, Kwesi stated that it is a 2016 model. Kofi bought the car and later discovers that the car was a 2007 model, making all the pre-contractual statements made by Kwesi untrue. The question is, should the court enforce that contract nonetheless, or is there a remedy? The answer to the question is the province of misrepresentation. Before we proceed, it is important that we understand the meaning of representation terms and what in fact misrepresentation is. Representation refers to statements which are intended to influence the other party into entering the contract, but which do not become part of the contract as terms of its terms. Terms define the scope and the extent of the obligations undertaken by the parties. It is important to know the distinction between the terms of a contract and mere representation, because the consequences are different. Even though a misrepresentation gives rise to certain legal consequences, it does not amount to a breach of the contract, since it does not form part of the contract itself. Now, what is misrepresentation? Misrepresentation is a misstatement of fact, or is simply a representation which is untrue or false. In contract law, not every misstatement of fact will found an action, but an operative misrepresentation. So I ask, what is an operative misrepresentation? It consists of a false statement of fact made by one party to another before or at the time of the making of the contract, which is intended to, and thus, in fact, induces the other party to enter into the contract. As I have already indicated previously, it is not every misstatement that is an operative one as to found an action. So to be actionable, a misrep must be a statement of an existing fact. So now, under what circumstances would a statement not be held to be a misstatement? 1. It must be a mere commendation. 2. It must be a statement of opinion. 3. It must be a statement of future intentions. And 4. it must be a statement of law. First, we look at the fact that it must be a mere commendation. Generally, commendatory statement or mere sales talk used in advertisement and promotional items are considered as mere past and have no effect at law or in equity. If the law were to regard mere commendatory talk as a term of a contract, commercial activity would have been near impracticable. It is in this regard that in Dimmock and Hallett, where an estate agent's description of land as fertile and improvable was held to be a mere commendation and not actionable. It must, however, be noted that there is a difference between indiscriminate praise and specific promises or assertion of facts which can be verified. The more specific or verifiable the statement, the more likely it is that it would be considered a representation of fact, as was the case in Khalil and Carbolic Smoke Bore Company, where the defendant's company published advertisements in newspapers claiming that it would pay £100 to anyone who got sick with influenza after using its product according to the instruction provided with it. Mrs. Khalil bought one, used it according to instruction, and yet got sick of influenza. When she sued for the £100, the defendant company asserted that the promise or the advertisement was a mere invitation to treat. However, the court rejected the argument and found an action and awarded damages for the lady. The reason of the court was that the fact that the company went ahead and deposited the amount promised in the bank as a guarantee for the payment of the reward or to any person who used the product according to instruction and yet contract influenza. So here the court's ruling was based on the fact that the promise made was, or the statement made in the advertisement was specific and verifiable. The second point, that the statement must not be a statement of opinion. Statements such as I think or I believe are at best a reflection of a person's opinion and not factual. Generally, an opinion on a matter which is unable to be proved cannot result in an action for misrep. A case illustrative of this point is Bissett and Wilkinson. In that case, a seller of a sheep farm in New Zealand was said to be able to support about 2,000 sheep. This was found to be untrue, but held not to be a misrep because the buyer knew that the seller had never farmed sheep in New Zealand and was only voicing an opinion. The question here is, are there situations where an opinion will be regarded as a statement of fact? The answer is yes. In a situation where one party possesses greater skill or knowledge than the other and represents by implication that he knows facts which support or justify the opinion, he may be liable in an action for misrepresentation if his opinion turns out to be untrue. We will have to contrast the case of Bissett and Wilkinson with Smith and land and house property. In the latter case, a seller described the occupier of property as let to a most desirable tenant. It was subsequently found that he had only paid rent erratically and under pressure. This was held to be a misrep because the seller was the only person who could have known this information, so he had an extra duty to take care over his statement as his opinion would be regarded as authoritative. Now, the third circumstance under which a misstatement will not amount to a misrepresentation is that the statement must be a statement of future intention. These are not generally actionable as misread, but if it can be established that the representor never intended to do as promised at the time of making the statement, then the claim may be regarded as a statement of fact. By this, it is meant a misstatement of the state of the mind of the representator. A case in point is Edmonton and St. Morris. In that case, a director of a company induced the plaintiff to lend money to the company by issuing a prospectus which stated that the money will be used for the improvement of the company's buildings and the expansion of the company's business. This was false. The directors actually intended to use the loan to pay off the company's existing debt. It was held that the statement made was clearly a lie and a misrepresentation of the intention of the company. I move to the fourth point, which is that the statement must be a statement of law. These have traditionally not been actionable as they are not regarded as statements of fact. Also, people are generally taken to be as equals before the law and to have equal access to the law. However, where a lawyer or similar person mistakes the law, he or she will not be absolved from liability for breach of professional duty of care on this basis. I now move on to silence and misrep. Silence and misrep. During this lecture, it has been severally repeated that misrep is a misstatement of fact. Is it the case that reticence or silence will not amount to misrep? Well, the general rule is that silence does not amount to misrep. There is no liability for failing to disclose relevant facts to the other party, even if those facts might have influenced the other party, and even if it is obvious that the other party has a wrong impression that could have been remedied by disclosure. In this situation, the principle of caveat emptor applies. It means let the buyer beware. The rule that silence does not amount to legal fraud is also subject to some exceptions. Remember, to every rule there is an exception. So the first exception is contract uberima fide, meaning contract involving utmost good faith. Contract involving utmost good faith. In certain contracts where only one party possesses full knowledge of all material or relevant facts, the law requires that party to show uberima fide. Example of this type of contract is insurance contract. The second exception is changed circumstance, where silence distorts a positive representation previously made. A representative may make a statement which is true at the time, but because of a change in circumstance, the statement may become untrue to the knowledge of the representative before the contract is concluded. In such a case, the representative is under a duty to disclose the change in circumstance to the representee before the contract is concluded. In Witt and O'Flanagan, the facts were as follows. In 1934, the defendant, a doctor, represented to the plaintiff, a potential purchaser of his practice, that the practice was worth £2,000 a year. This was true, but by the time the contract of sale was concluded in May the same year, the practice had dwindled and was bringing in only £5 a week. The defendant failed to inform the plaintiff of this change in the value of the practice before the contract was signed. It was held that the representation should be treated as continuing until the contract was signed. Since the statement became false to the knowledge of the representor, he should have communicated the changed fact to the purchaser before the contract was signed. In these circumstances, the silence amounted to misrepresentation. The third point under the exceptions to silence and misrep is partial disclosure, where a party, notwithstanding his right to remain silent, ventures to make a representation on the matter. It must be a full and frank statement. It must not be that what is withheld makes that which is said absolutely false. A case illustrative of this point is Curtis and Chemical Cleaning Company. In this case, the assistant informed the customer that the exclusion clause on the receipt excluded liability for damage to beads and sequins only, when in fact it excluded liability to any damage, howsoever arising. The court held that the statement made was a partial disclosure of the meaning of the clause, which conveyed a false impression, and therefore it amounted to a misrepresentation. What was omitted rendered what was stated false and misleading in the context. Let's now proceed to examine the requirement that the representation must be addressed to the party misled. The party misled must be the person to whom the representation was addressed. Do you remember the principle or the rule which was established in Bolton and Jones? That case states that where a person makes an offer to a particular person, it can only be accepted by the person to whom the offer is addressed. So in Pick and Gunny, the appellant sued the promoters of a company, claiming that he had purchased the shares of the company in reliance on certain false statements stated in the company's prospectus. The appellant was not a person to whom shares had been allotted on the formation of the company. He had merely purchased the shares from an allotee. It was held that the prospectus was addressed only to the first applicant for shares and that the intention to deceive could not be supposed to extend to people other than the first allottees. Upon the allotment of the shares, the prospectus had done its work. It was exhausted. The other requirement is inducement. So whoever the plaintiff, so to say, or speak, must show that he or she was induced. Another important requirement is that the representee must show that the representation operated on his mind to induce him to enter the contract. That is, that he relied on the misrep in deciding to enter into the contract. It follows that there can be no remedy for a misrep if the plaintiff never became aware that the misrep had been made before he entered the contract. 2. That the plaintiff was not influenced by the misrep or did not allow it to affect his judgment. 3. That if the plaintiff knew that the statement was false. The case of Atwood and Small is illustrative on the point of inducement. Here, the buyers of a mine claimed misrep when the amount of minerals in it were found to be less than that stated by the seller. However, it was held that they had relied on the result of their own private survey rather than the statement of the seller. So in that case, the court declined the relief of the plaintiff in that case on grounds that they were not influenced by the submissions or by the statement of the seller, and that they relied on their own survey results. But let's now just suppose that case with the case of Redgrave and Head. In that case, the court held that even if the representee tests for accuracy but fails to discover the truth, the representee may still be regarded as having relied on the representer's untrue statement. I must say here that the case of Batten and County Northwest, which was reported in 2002, found that there is a rebuttable presumption that a claimant relied on an inducing statement if a reasonable person would have done so. Let's now deal with kinds of misrep, the types of misrep. Basically, there are three kinds of misrep. They are fraudulent misrep, negligent misrep, and innocent misrep. We now proceed to discuss them one after the other. Let's take fraudulent misrep first. The definition of fraudulent misrep can be found in Lord Herschel's formulation in the House of Lords case, Derry MP, where it was said that a fraudulent misrep was a false statement made knowingly or without belief in its truth, or recklessly careless without it being true or false. In simple terms, a fraudulent statement is one which the maker does not honestly believe to be true. The court regards fraud seriously and will therefore look for more than mere negligence or carelessness. And since the proof concerns a state of mind, fraud is very difficult to prove in most cases. In the case of Ahmed and Ad, which was reported in 2004, it was stated that the standard of proof should be the criminal standard, that is beyond reasonable doubt. What is the Derry MP case about? In Derry MP, a company obtained permission to run trams by animal power. They applied for permission to run the trams by steam or mechanical power if the consent of the Board of Trade could be obtained. The directors of the company believed that the board would give its consent as a matter of course, since they had already submitted their plans to the board and no objection had yet been made. The directors therefore issued a prospectus saying that the company had the right to run trams by steam or mechanical power. The respondent purchased shares in the company in reliance on this representation. The Board of Trade refused to give their consent and the company was wound up. The respondent sued for fraudulent misrepresentation or deceit. The court held that to succeed, the plaintiff had to prove fraud and that the element of fraud had not been established here, since the plaintiff had not shown the absence of an honest belief on the part of the directors in the truth of the statement they made. The fact showed that the directors honestly believed that the statement they made was true, since they had sufficient ground to believe that the permission would be granted. So the point here to note is that the plaintiff could not prove the fraud on the part of the directors because per the definition of fraudulent misrep, there must be absence of honest belief in the statement made, and here same was not proved. Now, if fraud is proved, two remedies are available. One, the plaintiff may claim damages, and two, the contract may be rescinded. To rescind a contract means to cancel or declare a contract void as having no legal force. Again, if the contract has not been performed, the party misled may repudiate the contract, that is, refuse to perform his obligation and sue to recover any money paid under it. The second type of misrepresentation is negligent misrep. A representation is negligent if it is made carelessly and in breach of a duty owed by the representor to the representee to take reasonable care that the representation is accurate. Generally, a misrep cannot be regarded as negligent unless the representor owed a duty of care to the representee. Initially, at common law, there was no liability at all for negligent words or misstatement, especially where the only damage resulting was financial damages as opposed to physical damage. All misrepresentations were classified either as innocent or fraudulent. In 1963, the House of Lords changed this position by stating, even though obiter, that in certain circumstances where a negligent misstatement resulted in financial loss, damages may be recovered in tort once a fiduciary relationship existed between the parties. So in Nocton and Ashburn, this principle was applied to negligent advice given by a solicitor to his client. The view that an actionable negligent misrep could arise only out of contractual relationship or fiduciary relationship between the parties was upheld in the case of Candler and Crane, Christmas and Co. For emphasis, the court in the Candler case held that a false statement made carelessly but not fraudulently by one person to another, though acted upon by the other to his detriment, was not actionable in the absence of any contractual relationship between the parties. Then in 1964, the court recognized in Hedley-Bine that a duty of care could be established even if there was no contractual or fiduciary relationship between the parties. Such a duty could be deemed to exist if there was a special relationship between the parties, which demanded that care should be taken that the statement being made was accurate. In effect, the majority in Hedley-Bine and Heller and Patines overruled the majority decision in Candler and Crane Christmas. In order to clarify any doubt about when this special relationship exists, the court posed the question, when would these special relationships be deemed to exist? In answering the question, the court stated that such a special relation would be deemed to exist in cases involving professional or business relationships, where even in the absence of contract, it can be established that the representor knew or ought reasonably to have known that the representee was likely to act or rely on the representation to his detriment. It is on this basis that the court in the case of Esso Petroleum versus Maggie held that since the tenant relied on the salesman's superior knowledge and experience, a duty of care arose between them and the company was liable for the negligent misstatement. We are now on the last type of misrep, innocent misrepresentation. An innocent misrepresentation is an untrue statement made in good faith with honest belief in its truth, intended to induce a party to enter into a contract. An innocent misrep is one which is neither fraudulent nor negligent. It generally gives the party misled the right to rescind the contract, but it does not entitle the party misled to claim damages. A party misled may repudiate and set up the misrep as a defense to any action brought against him for breach of contract or for specific performance of the contract. Now, what are the remedies in cases of innocent misrep? The party misled has the right to rescind the contract, but he cannot also claim damages or only an indemnity. It must be noted that rescission, being an equitable remedy, its grant is discretionary and subject to certain limitations. These limitations are: 1. Restitution. The fundamental principle here is restitutio restitutio in integro. It means restoration to the original or pre-contractual position. In order to restore the parties, the court determines whether there is a possibility of restitution. Rescission is, however, not possible where the subject matter has been so altered as to change its character. The second limitation to rescission is affirmation of contract. A contract is affirmed if the representee declares his intention to proceed with the contract or does some act from which an intention may reasonably be inferred. Then the third one is lapse of time. Lapse of time may act as a bar to the right of rescission. An important distinction must be made here. In the case of fraudulent misrep, lapse of time of itself does not act as a bar to rescission, but may be evidence of affirmation. This is because the court takes the view that time only begins to run from the discovery of the truth. In the case of innocent misrep, however, the right to rescind may be barred by the lapse of time, even without any evidence of affirmation. Then, the other bar to rescission or limitation to rescission is third-party rights. The right to rescind a contract may be barred by intervention of third-party rights. If the contract is voidable, then once a third party acquires an interest in the subject for value in good faith and without notice, the party with the right of rescission loses his right to rescind. Therefore, a party who has been induced by fraud to sell goods cannot rescind the contract after the goods have been sold to a third party. This brings us to the end of the discussion on misrepresentation. Thank you.